under the, I don't know the Florida Constitution, obviously, but your argument was that it was unconstitutional under state constitution or federal?
So, Senator, it wasn't my argument, but the reasoning of the opinion that I authored on behalf of the court is that the Due Process Clause of the 14th Amendment to the United States Constitution requires, as with any other circumstance when someone's substantial rights are at issue, notice and opportunity to be heard, essentially a opportunity to provide an explanation to the court why the court should or should not take the contemplated action. And there's a body of precedent that the opinion cites regarding the fundamental requisites of the Due Process Clause being notice and opportunity to be heard.
Welcome to America Viewpoint, where we speak the truth, defend our freedoms, and fight for the values that made this nation great. No censorship, no woke spin, just bold, unfiltered commentary from real Americans who love this country. If you're tired of the lies and ready to stand for faith, family, and freedom, hit that like button, subscribe, and ring the Liberty Bell, because this is where the fight begins.
Ranking member.
It's been a long time since I took a bar exam, and I remember getting the envelope that said with good news that I had been accepted, and I breathed a sigh of relief to think I'd never have to face another test. Well, you've just gone through the Senator Kennedy bar exam. It's been a tough one for a lot of nominees. And lucky for us, he doesn't ask his colleagues these questions, only the nominees. So I wish you well, and I acknowledge you asked some tough questions, Senator. Judge Pratt, just a few weeks ago, you...
It's only a position for life,
Understood.
Mr. Chairman.
Judge Pratt, a few weeks ago, you wrote an opinion in which you held that a Florida law allowing minors seeking abortions without parental consent but with judicial waiver was unconstitutional. The case involved an appeal from the trial court's denial of a 17-year-old's application to obtain a judicial waiver of the parental notification and consent requirements for an abortion. Under Florida law, judicial waivers in this context have been permitted. However, your decision held that Florida's judicial waiver procedures were unconstitutional and violated the parent's due process right. This wasn't something you wrote in an op-ed piece, nor was it a case you argued zealously on behalf of a client. This was last month, and you wrote this opinion as a state court judge. In commenting on your opinion, one lawyer said, judicial override doesn't even begin to describe what this judge did. There are also serious concerns with your decision's potential impact on victims of incest or abuse. So, should a minor who is sexually assaulted in your state be forced to give birth if her parents do not consent to her having an abortion?
Senator, my opinion on behalf of our court expressly made clear that that was not a situation that was presented in the case. The case concerned a waiver request on the basis that the minor asserted that it would be in her best interest not to include her parents, not to allow her parents to be notified of her contemplated procedure. And as the opinion, explains, I think I don't want to go behind the face of the opinion, but I'm happy to explain the opinion. The opinion holds that the parents have, at a minimum, a due process right to notice an opportunity to be heard, and this is presumptively fit parents, have a right to notice an opportunity to be heard if the state seeks to abridge or to remove their right to be involved in the medical decisions of their children. So that is the basis of the opinion.
I think you went further than that, as I understand it. Your decision held that Florida's judicial waiver procedures were unconstitutional and violated the parents' due process rights. Unconstitutional under the, I don't know the Florida Constitution, obviously, but your argument was that it was unconstitutional under state constitution or federal?
So, Senator, it wasn't my argument, but the reasoning of the opinion that I authored on behalf of the court is that the Due Process Clause of the 14th Amendment to the United States Constitution requires, as with any other circumstance when someone's substantial rights are at issue, notice and opportunity to be heard, essentially a opportunity to provide an explanation to the court why the court should or should not take the contemplated action. And there's a body of precedent that the opinion cites regarding the fundamental requisites of the Due Process Clause being notice and opportunity to be heard.
Different states have different laws, and certainly the judicial waiver is put in place so that when there's a question of parental consent, there's an option for the victim to petition the court for permission to apply the waiver. And as I understand it, you found that petition to apply the waiver unconstitutional. That's the way I read this. Let me ask each of you, we've had a recurring question here about the impact of a court order. How seriously should a party to a conflict take a court order? Judge Ortaw?
Very seriously.
And do I have the right, if I'm in your court, or any court for that matter, and a decision is reached, to say that I just don't agree with it, I don't have to live by it, or am I bound by that order until I've exhausted rights of appeal, for example?
Well, Senator, there are stays that can be pursued. Of course, there's appeals that can be exhausted that may be able to be exhausted. You may be able to post a bond to exhaust such things. You may be able to move for rehearing on it. There may be some exceptions, but for the most part, court orders are court orders.
Well, and I think you just heard, you sat through several hours of questioning on a potential nominee for the circuit court as to whether or not he was following the court order, oral or written, I'm not sure, when it came to launching a plane with detainees in it to another country. So this is a serious question which is going to recur frequently here, I'm afraid, under this administration. I yield at this point.
Folks, today we witness something that every freedom-loving American needs to see. A Trump judicial nominee standing tall, calmly dismantling the left's tired old narratives and reminding D.C. exactly what the Constitution says. Judge Pratt, under fire from Senator Dick Durbin, one of the Senate's top liberal foot soldiers, didn't flinch. Durbin tried to corner him on a recent opinion involving a Florida minor seeking an abortion without parental involvement. Let me say this loud and clear. Judge Pratt was right. The Constitution, not political correctness, is the law of this land. And what Judge Pratt laid out was simple. Parents have rights. The 14th Amendment guarantees due process, and that means if the government tries to take away a parent's ability to be involved in a life-altering medical procedure involving their child, that parent has a right to be heard. But what does Senator Durbin do? He pivots, bringing up hypothetical cases about incest, abuse, anything to stir emotion and sidestep principle. And Judge Pratt, respectfully, didn't take the bait. He stayed focused. He said, that's not what this case was about. And you know what? That's integrity. We've watched for years as radical activists try to erase parental authority, whether it's at school board meetings, in gender ideology curriculums, or now in the courts. But Judge Pratt said, enough. He drew a line in the sand and reminded the Senate that our laws are built on process, not emotional manipulation. Let's be clear, this wasn't some off-the-cuff remark. This was a carefully written legal opinion, and it terrified the left because it stood up for the family, for order, for constitutional boundaries. Durbin even asked whether court orders should be followed, and Judge Pratt doubled down on the importance of law and order. Imagine that. We have to explain to U.S. senators that court rulings aren't optional. That tells you how far we've fallen. This wasn't just a confirmation hearing. This was a masterclass in judicial restraint, constitutional wisdom, and backbone. And it proved that President Trump's picks are still delivering, long after his time in office. To every patriot watching, this is why we fight. This is why we vote. This is why we never give up. Because the stakes are too high for our children, our rights, and our future. This is America Viewpoint, where we don't whisper, we roar. We stand tall, speak loud, and never back down from defending truth and liberty. If this message fired you up, smash that like button, hit subscribe, and turn on notifications, because the fight for America doesn't end when the video does. Until next time, stay strong, stay free, and may God bless the United States of America.